Thank you very much, everyone, for joining us. Welcome to this webinar that is hosted by the Center for Human Rights, the Center for Human Rights based at the University of Pretoria. We have been having these webinars, and this is every Tuesdays, every Thursdays, but because this particular one is a commemorative event and it falls on a Monday, that is why we are having this one on Monday. And today we are gathered virtually to commemorate the International Day for Universal Access to Information, which is a day that was proclaimed by the 74th Ordinary UN General Assembly, and previously it had been through a resolution declared by UNESCO that 28th of September every year will be International Day for Universal Access to Information. So all this was in recognition of the significance of access to information. And we see the significance of access to information as a governance tool, as a development tool, as a participatory tool, as a transformative tool. And it was in this recognition that we are now commemorating this day, because when we look at the right of access to information and issues around service delivery, on issues around corruption, on issues around development, it is a very important element that needs to be recognized, that we need to continuously speak about. If you look at the SDGs, they also make mention of access to information, so which means access to information is also a development tool. It's also a tool for poverty eradication. And without wasting much time, I just want to say that in commemorating this day, what we are trying to do is to try and analyze the role of access to information when we are looking at tackling corruption. This is because the situation in Africa is mainly comprised of a culture of secrecy that is breeding corruption, that is hindering transparency, that is hindering accountability. Yet those are very important elements of governance and democracy. But in the context of Africa, we are lagging behind, and there are significant gaps in that area. So we are trying to share perspectives on the realization of access to information on the continent, particularly with regards to transparency issues and accountability and governance. And in addition, also, we want to also look at the aspect of whistleblower protection frameworks in enhancing transparency, in enhancing accountability, and also draw your attention to the efforts that have been made by human rights bodies like African Commission on Human and People's Rights in setting standards on the realization of access to information. So in this regard, we have the declaration, the new instrument which was adopted last year, the Declaration of Principles on Freedom of Expression and Access to Information in Africa. Before that, the Commission adopted a model law, which is basically a guide to state parties as to how they can go about it in developing access to information legislation. And also in the context of elections, there is also the guidelines on access to information and elections. So as we are looking at this from this perspective, we are also trying to continuously encourage civil society to continue advocating for the adoption of access to information legislation. And also, as we are having a conversation around access to information, it's also important to look at the right to privacy, because these are the privacy is also one of the exceptions when you're looking at the access to information regime. So both rights are significant, both rights are important, but we have to find that balance between the rights. And we have our stakeholders here who are going to help us in understanding that balance. So in commemorating this day, the International Day for Universal Access to Information. We have partnered with the Special Rapporteur on Freedom of Expression and Access to Information in Africa. And the current Special Rapporteur is Commissioner King. Commissioner King, welcome. And then we have Article 19, Eastern and Western Africa. Article Eastern Africa is represented by Sandra. Sandra Waswa, she's a senior programs officer with Article 19 East Africa. From Article 19 Western Africa, we have Alfred Bulakali, he's the Deputy Regional Director. From Transparency International, we have Sheila Masinde, and she is the Executive Director. From MISA Zimbabwe, we have Tawani Moyo, and Tawani is the Country Director. From the South African Human Rights Commission, we have Dr. Chanel, and Dr. Chanel is the Deputy Information Officer and Senior Researcher. From the Information Regulator of South Africa, we have Advocate Lebohang Strum Nzama. She is a member of the Information Regulator. And representing the civil society in South Africa, we have Mr. William Bird, and Mr. William is the Director of Media Monitoring Africa. So welcome everyone, and thank you very much. And in the interest of time, I'm going to ask Commissioner King to give us the keynote address, and then we will move on to the other speakers. So Commissioner King is going to set the tone, and she's going to speak about efforts that have been done by the African Commission in the context of the discussion that we are having today. Commissioner, over to you.
Thank you, Lingiwe. Thank you, dear participants, ladies and gentlemen. Today, 28th September 2020, we are gathered, albeit virtually, to commemorate the International Day for Universal Access to Information. As the Special Rapporteur on Freedom of Expression and Access to Information, a special mechanism of the African Commission, it gives me great pleasure and a singular honor to participate in this celebration for this important day. And this is my first participation as the Special Rapporteur. Allow me, dear participants, to take the opportunity at this juncture to thank the Center for Human Rights for convening this virtual commemoration. I hope that this webinar will be an opportunity for us to take stock of developments which have been made with regards to the right to access information, in addition to facilitating constructive dialogue on how to effectively promote and protect this right. Ladies and gentlemen, in the unprecedented times we are living in, the significance of the right of access to information cannot be overstated. This was highlighted in the Commission's press statement on human rights-based effective response to the novel COVID-19 virus in Africa, issued on 24th March 2020, which stressed the importance of factual, regular, intelligible, and science-based information as a means to ensure the public's protection. You will agree with me that the right to access information has never been more important. However, there have been reported cases of lack of up-to-date information in some states, in addition to reports of restrictions on accessing the internet, blocked social media platforms, or other communication services. These actions, or lack thereof, can have the deleterious effect of curtailing the public's access to crucial health information, which may be needed not only to protect them from contracting the virus, but also containing its spread. It is in this vein that my immediate predecessor, in a press release issued on 8th April 2020, called on all African states to take all measures to guarantee respect and protect the right to freedom of expression and access to information through ensuring access to internet and social media services, especially during the COVID-19 pandemic, and stressed that states should not disregard rule of law dictates by exploiting the pandemic to establish overreaching interventions. Dear participants, ladies and gentlemen, the right of access to information is guaranteed in a number of international and regional human rights instruments, including Article 19 of the Universal Declaration of Human Rights and Article 19(2) of the International Covenant on Civil and Political Rights. In the context of Africa, this right is enshrined in the African Charter on Human and People's Rights, the African Charter, which provides in Article 9(1) that every individual shall have the right to receive information. In order to elaborate on the scope of Article 9 of the African Charter, the Commission adopted the Declaration of Principles on Freedom of Expression and Access to Information in Africa, the Declaration, during its 65th ordinary session held in November 2019. As many of you may be aware, the Commission undertook a process to revise the previous declaration, which was adopted in 2002, in order to include salient provisions on the right to access information, which was not substantially covered in the earlier declaration. At the outset, the revised declaration stipulates the following in Principle 1.1. Freedom of expression and access to information are fundamental rights protected under the African Charter and other international human rights laws and standards. The respect, protection, and fulfillment of these rights is crucial and indispensable for the free development of the human person, the creation and nurturing of democratic societies, and for enabling the exercise of other rights. Additionally, the main section on the right of access to information can be found in Part 3 of the revised declaration, from Principle 26 to Principle 36, covering issues such as proactive disclosure, the duty to create, keep, organize, and maintain information, the need for an oversight mechanism established by law to monitor, promote, and protect the right of access to information, protected disclosures in the public interest, sanctions for failure to proactively disclose information, to name a few. I would like to encourage all the participants in this webinar to utilize the revised declaration in order to ensure the promotion, protection of Article 9 of the African Charter in general, and the right of access to information in particular in all of the states where you work. The declaration can be accessed on the Commission's website in the 4 AU languages. Ladies and gentlemen, as illustrated above, the legal framework for the promotion and protection of the rights to access information is certainly not lacking in Africa. However, as is the case with other rights, lack of consistent and effective implementation of this right by state parties hinders its full realization. Excuse me. It goes without saying that the right to access information is best realized and implemented on the basis of national laws regulating the right. This reality spurred the Commission to begin a process of ensuring that the right to access information in Africa was effectively promoted and protected at the national level. Accordingly, in recognition of this need to develop a tool to assist realization of the right to access information in Africa, the Commission mandated the special mechanism on freedom of expression and access to information through Resolution 167 to develop a model access to information legislation for Africa. Following a 2.5-year process of drafting, the Commission officially launched the Model Law on Access to Information in Africa, the Model Law, during the Commission's 53rd ordinary session in April of 2013. The Model Law is a practical tool designed to specifically help state parties meet their legislative obligation to give effect to the right to access information. In summary, the Model Law provides the following: The right to access information is guaranteed to everyone within the state and not only citizens. The requirement to disclose information is applicable to public bodies, private bodies, in addition to relevant private bodies, which make reference to bodies which would otherwise be private, but which are owned, controlled, or even financed through public funds, or which are performing a public function or service. It also applies to information holders who are required to create, organize, and keep information, and public institutions are mandated to proactively disclose a wide range of information contained in the model law. It also provides for requests for information that this can be made in writing and orally, in which case the information officer must assist the requester by recording the request in writing. No fees are payable for accessing information, only the cost of reproduction of the requested information, and where the information is requested by an indigent person, the reproduction fee is to be waived. The 48-hour rule on information disclosure where information requested is for the purpose of safeguarding the life or liberty of a person. Following the adoption of this model law, and in order to maximize the potential to transform the access to information landscape on the continent, my predecessors undertook a series of advocacy initiatives to raise awareness on the model law, in addition to highlighting the importance of enacting national legislation on access to information. Such initiatives included advocacy visits to the state parties to interact with stakeholders on development of national legislation, press releases, and letters of appreciation commending the eventual adoption of the laws. It is my hope that I will continue this important work, both with state officials, civil society organizations, and with any other relevant stakeholders to encourage the adoption and effective implementation of national laws on access to information. While the current status quo may hinder physical interaction, I encourage all relevant stakeholders to involve the Commission and my mandate in particular in any virtual consultations which may be undertaken with a view to developing access to information legislation. The model law on access to information has been a significant development for promotion of the right of access to information in Africa. In addition to creating a framework to guide governments in developing national legislation in line with Article 9 of the African Charter, as well as Part 3 of the Declaration, the model law also provides a framework for the Commission to engage with state parties on the quality of their access to information laws and its implementation. No doubt, the model law will continue to help transform the right to information landscape in Africa. The model law can also be accessed on the Commission website, again in all 4 AU languages. Ladies and gentlemen, another advocacy tool developed by the Commission related to this important right is the guidelines on access to information and elections in Africa. The impetus for developing these guidelines was the realization of the importance of the right of access to information to the creation of a conducive environment for free, fair, and transparent elections. These guidelines seek to elaborate on the information that should be proactively disclosed by all the key players in the elections, including political parties, election observer missions, the media, among others. The guidelines were subsequently adopted by the Commission in 2017 and can also be accessed on the Commission's website. Even in the unique situation we are living in, a number of elections have been held in Africa this year, including Burundi, Benin, and Malawi. More elections are scheduled in the coming months, including in Uganda and in Ghana. And there are a number of scheduled elections for 2021, which may be held subject to the COVID-19 pandemic. If these elections do proceed, access to prompt, credible, and clear information, excuse me, will be of paramount importance. Ladies and gentlemen, in closing, I would like to reiterate that access to information, in addition to it being a basic human right, it is also an enabling right and a vital tool for realizing a variety of other political, social, and economic rights. Just as there is no democracy without the protection of human rights, likewise, there can be no viable human rights agenda without respect for civil and public liberties, amongst which is the right of access to information. As we gather today to commemorate the International Day for Universal Access to Information, I would like to call on all stakeholders participating in this webinar to commit to greater efforts towards the promotion and protection of the right to access information. This can be done through increased advocacy at the national level, encouraging adoption and effective implementation of an access to information law based on the model law, reference to the tools developed by the Commission, including the declaration and the guidelines highlighted earlier, in addition to increased engagement with the Commission through participation in the Commission sessions, transmitting reports of violations of this very important right to the Special Rapporteur, and submitting shadow reports on the implementation of the right to access information with a view to holding states accountable during consideration of their periodic reports in accordance with Article 62 of the African Charter. Ladies and gentlemen, dear participants, with concerted efforts, taking advantage of the current climate of greater awareness of the importance of this right, we can collectively move into an era of unprecedented recognition of the promotion and protection of the right to access information, and I am very optimistic that this can be achieved on the whole continent. Thank you very much, and I wish you a very good day. Thank you.
Thank you very much, Commissioner King, for setting the tone for today's discussion on access to information. As we are commemorating the International Day for Universal Access to Information. So as we have heard from Commissioner King, the various efforts that have been made by the African Commission, and it is now the duty of us as stakeholders to engage in advocacy strategies, and also the duty of the state parties to the African Charter to create a conducive environment for the enjoyment of this right. I'm going to call upon Sheila from Transparency International Kenya. And before I give you the opportunity, Sheila, I just want to mention that in our initial invitation, we had used the logo of Transparency International Global, not Kenya, and we want to sincerely apologize for that inconvenience, and that has since been corrected. It's now, our invitation now has the Transparency International Kenya logo. So please accept our apologies for that. So I'm going to call upon Sheila to give us just a minute about Transparency International Kenya, and then address us on the role of access to information in fighting corruption in Africa. Over to you, Sheila, and I'm giving you 10 minutes. Thank you.
Thank you. Thank you very much, Lengiwe, and thank you for the clarification on the logo. No worries. We're just happy to be able to participate in this very important discussion today as we mark the Right to Information Day. So thank you for this opportunity. About Transparency International Kenya, we are a not-for-profit organization working towards a transparent and corruption-free society. And we're one of the autonomous chapters of the Global Transparency International movement. And we're all together bound by a common vision of a corruption-free world. So for us, as Transparency International Kenya, access to information is a key right which we have advocated for actively in the last 21 years of our existence in Kenya. So literally by the time we were established in Kenya, one of the first things on our agenda was to push for the right to information, because we then realized that for us to be able to effectively fight corruption, promote good governance, transparency and accountability and integrity in this country, it would be virtually impossible to do so without a right to information regime, a legal and policy regime. So we have been on the front line of advocating for legislation on freedom of information, together with other civil society CSO partners including Article 19 East Africa, which is represented here, under the ban of the FOI network for several years. And following the enactment of a law in 2016, which followed the inclusion of a provision on the right of the public to access information, which was that provision was included in the constitution that was promulgated in 2010, we then started pushing for a law and are now currently monitoring the implementation of that law. We have also taken matters to court to further push for the right to access information, and we found this very, very necessary, not once, but several times, because even in the presence of a strong provision for access to information in our constitution, even with the presence of a law, we still have found it very difficult to get information from the government, particularly information regarding expenditure. And that really has now made us, go to court as a last option to seek redress. So, for instance, currently, I'll probably just go to the context under which we're operating under currently, and that is under the crisis of COVID-19, which has affected, every one of us living in this world today. And I'll also just relate that with today's theme of saving lives, building trust, bringing hope. I think it's important that I just also share that one of the things we are currently really pushing for in this context of COVID-19 is information on the government actions and decisions that are being made, particularly decisions and actions on financial expenditure. So currently we have taken another matter to court to compel information from government in regard to actions it has taken in responding to the pandemic in this country. And one of the aspects includes a demand for financial information on how money has been spent. And I think every other day currently, we are writing a request for information to one government entity or another because of the situation that we are in right now. And really what that has shown us is that we still have a great challenge in terms of accessing information in this country. And I think for us, one of the things that we have demanded right now is we need full accountability. We need proper accountability mechanisms. They need to remain effective, particularly the right to information during this unprecedented crisis, because we believe that the right to information has the potential to play a major role in ensuring successful responses to COVID-19. The transparency and accountability mechanisms that we put in place today will greatly determine how we recover, not just as Kenya, but even other countries from this crisis, particularly as pertaining to economic recovery, because it will be pegged upon how we utilize resources and whether we have accountability to ensure that every single citizen, every single stakeholder is aware of how money is being spent during this time. So it's also very, very critical to note that the current emergency presented by COVID-19 does not allow governments to act outside of the frame of law, because we've also seen countries where they've been, they've proclaimed a state of emergency, and because of a state of emergency, it then means that if there's any law on access to information, then that is then suspended. In our case in Kenya, we have demanded that the government must conform to the constitution. As I said, we have a constitutional right to access information. And the other thing that we have also demanded is proactive disclosure. Very, very crucial at this time, because the government should be making increased efforts to improve disclosures on all decisions made, all actions taken, and all funds spent in regard to the pandemic. But beyond the pandemic, as I just go to the second bit of my presentation, because I believe we will overcome this pandemic. We can't say when at this time, but we will for sure overcome it. And so we also have to continue to look at other aspects of access to information. As I mentioned, we are currently actively monitoring the implementation of our law. And for us, it remains a key tool to combat corruption, because we believe that a well-functioning right to information system is critical for exposing and deterring abuses of power and supporting the fight against corruption. So access to relevant, timely, and accurate information provides individuals with the knowledge required to participate effectively in the democratic process in any democratic society. For instance, for us in Kenya, we have also the right to public participation. It goes hand in hand with access to information, because members of the public cannot participate in governance processes if they do not have information on these same processes. So it is actually a prerequisite for good governance and public participation and other aspects of good governance. We believe also that RTI fosters openness and transparency in decision-making, because where we have an informed public, then it is also likely to be vigilant against corruption within and outside government. So that when we say information is power, we don't just take it literally, because that information is what enables citizens to protect themselves against all kinds of abuses and violations, human rights abuses, and also economic abuses in the form of corruption. When you look at the United Nations Convention Act, you look at the United Nations Convention Against Corruption, that is the UNCAC, it contains a number of references to access to information and points to specific steps that governments must take to promote transparency. Now, the potential of the UNCAC is threefold. It provides a global framework for combating corruption by establishing worldwide standards that bind countries at all levels of economic and democratic development. It also encapsulates the measures necessary to prevent corruption, including access to information and promotion of transparency in private finance, public procurement, and national anti-corruption agencies. It also sets standards for the criminalization of corrupt acts. And the access to information provisions in UNCAC commit states to implement changes at the national level. And this then require access to information laws, open data systems, beneficial ownership registers, and financial and asset disclosure laws. So as a core element of fighting corruption, UNCAC requires states to make information available about their activities and to engage with civil society. In regard to universal access to information in Africa, just briefly, maybe what I can mention is that in the last Corruption Perceptions Index by Transparency International, which was published in January this year, and that was for 2019, Sub-Saharan Africa was the lowest scoring region, with an average of 32 out of 100 in the index. And basically, this score paints a bleak picture of inaction against corruption in Africa, because the global average was 43. And there is a strong nexus between corruption and access to information. And because I can see a lot of academics here, I would like to challenge them here to further research on this connection, so that we can push states, advocate further for the adoption of access to information laws in countries where these do not currently exist. As I conclude, I just want to give some recommendations which I think are necessary to enable us to improve our right to information policy and legal frameworks in different countries, but this is based on our experience in Kenya. One of the things we need to do is generate political will, commitment to ensure enactment and enforcement of ATI laws, and this needs to be championed from the top leadership. And this includes also awareness building and understanding of public officials and their roles and responsibilities. We need to develop a culture of the right to information. We always say that a law is as good and as strong as its implementation. And we therefore need to build a strong demand side of media and citizens who are testing our access to information systems and demanding all kinds of information. For this to happen, we then therefore need intensive legal education and awareness and freedom of information campaigns to raise requisite awareness amongst the population and stimulate filing of requests. We also need to push for government efficiency and information management. An access to information law is not only a tool to uncover corruption, it can also be a very strong preventive measure. And in fact, one of the things we're now building upon in the fight against corruption is to strengthen prevention measures so that you don't have to get to the point we are reacting to corrupt incidents or corruption cases, after the event, after money has been stolen. What can we do to ensure that public resources are at the first step insulated from theft? One of the things that we need to foster is strong implementation of an access to information law, because this helps prevention of corruption by highlighting poor administration practices regarding how public funds are being expended. We also need to enhance the use of internal information systems. We're in the IT world, thanks to COVID, that has pushed us further into the digital space. So we need to explore the use of IT systems, web portals, filing systems, digital records and archive systems, and procedures, especially in regard to sharing and storing of financial information, which we always insist must be published in open, accessible formats and platforms. I think this will go a long way in terms of building a culture of access to information and preventing corruption. I really want to stop there, but I just want to say thank you again for the opportunity. As TI Kenya, we'll continue to play our part, hold the government accountable, especially in fully implementing our right to access to information and also in implementation of our access to information laws. We also want to ensure that we will also ensure that we continue to create awareness of the role of different stakeholders, citizens, media, the state, in regard to access to information. Thank you very much, Lengiwe, for this opportunity, and I look forward to engaging in other parts of this program. Thanks.
Thank you very much, Sheila, for that. We now have a picture of the situation in Kenya with regards access to information and the efforts that are being done by Transparency International. And in your presentation, Sheila, you mentioned the aspects of COVID-19, the situation that, the global pandemic that we are faced with, and the use of public resources. There have been a lot of talk about corruption and misappropriation of those resources. And it brings in the issue of access to information, transparency, accountability. So this conversation is very important within the general context, but also specifically under COVID-19. So I'm moving over to you now, Thabani. In the issue of COVID-19 and other issues in Zimbabwe, there's been a lot of talk about public resources, corruption, the culture of secrecy, lack of accountability. Please take us through what is happening in Zimbabwe in that regard, and also maybe specifically also address us on the issue of whistleblower protection.
Thank you very much, Lengiwe, and also to thank you specifically for proposing this rich panel, and special thanks to Commissioner King. Our paths seem to cross frequently rather than not this past month. In a nutshell, I want to thank you again for giving us the opportunity as MISA Zimbabwe to showcase the challenges around access to information, right to privacy and expression in Zimbabwe. MISA Zimbabwe is a part of the regional network with a presence in 10 countries in Southern Africa. And MISA Zimbabwe works within and without Zimbabwe to promote right to expression, access to information, right to privacy and media freedom. It is in this regard that we feel privileged to be seated in this space. Firstly, Zimbabwe is going through a process of reviewing its laws, and probably this is one of the key steps that have presented itself in quite a long time. And as we know in politics, once a window opens, we try as much as is possible to influence the outcome incrementally. But we risk squandering the opportunity if we do not take it in a holistic manner. And as such, in reviewing our laws, we have identified the archaic Access to Information and Protection of Privacy Act, and Broadcasting Services Act as the two pieces of legislation that the government believes they need to be repealed or reviewed extensively. In terms of IPA, which is wrongly named as Access to Information Law that came at the turn of the century, we have managed to so far partially repeal it because it had three key legs it stood on and broad components that it regulated: access to information, media regulation, and privacy, all lumped in one law. So far, the access component have been completed, leading to the promulgation of the Freedom of Information Act, which came into force around June, July this year. So in terms of its prominence, this is the law which was supposed to repeal IPA in total. However, the regulation arm of the Act is still in Parliament, where we are still engaged as stakeholders and the government on the most progressive way of regulating the media industry. While the privacy component is fragmented, one arm being sponsored by Ministry of Information, the other one being sponsored by the Ministry of ICTs. We hope that we'll utilize as much as possible this window of opportunity and make our laws progressive and responsive to the changing tastes of the Zimbabwean people. The second issue is that Zimbabwe is also coming up with a cyber crime, cyber security and data protection bill, which is before Parliament. The speed with which it is being pushed, it is almost overtaking the bills and that came into Parliament almost 2 years, 2 to 3 years ago, because it has serious challenges on the right to privacy. These we cannot speak them as divorced to each other. That is the right to privacy and the right to information. These are intertwined. Simply put, they mean the same. If you compromise the right to privacy, literally you are going to compromise the right to access information that is critical for informed decision making. Thirdly, these issues are broadly provided for in our Constitution through Section 57, Section 61, and Section 62, which speaks to right to privacy, right to information and media freedom, and a right to access to information holistically. And they must also be understood and read together with the model law at AU and the recently reviewed declaration on principles of expression and access to information, as it sets the foundation for a progressive access to information law. Having said that, Zimbabwe has no sufficient whistleblowing mechanisms in place. And this has been evidenced by many developments, be it at parastatals, be it at media. Only around 2019, you saw the workers at the utility power supply, ZESA, being the whistleblowers on corruption being exposed and being fired, literally because the law is weak in terms of protecting whistleblowers. This is also compounded by the fact that the level of corruption is structured to the extent that the law is weakened for a purpose of further consolidating the same. And this has spilled over to the media in this case around, whereby in the media you saw the cases of investigative journalists such as Opo Chingono spending 4 months in prison for writing investigative pieces, and their accounts, online accounts, being allegedly tampered with, both Twitter and Facebook, with the sole purpose of trying to expose the whistleblowers who are feeding the media with records pertaining to the corruption around the procurement of COVID-19 protective equipment and protective wear. This puts to the fore the fact that Zimbabwe, in its current form, though it was one of the first movers at the turn of the century to come up with an access to information law, practice and the law remain weak in terms of consolidating and galvanizing whistleblowing. And this now is being further complicated with what I outlined in my introductory phases, that we are in the process of coming up with the cybersecurity law, which in Section 31 speaks briefly on whistleblowing. And tied to that, the Official Secrets Act limits the protection of whistleblowers, which is rarely provided for at law. And it further, establishes these barriers to ensure that there's minimum protection for anyone who tries to expose corruption as it emerges in the country. Why is the government pushing the cyber security and data protection law? For the sole purpose of ensuring that the process of undermining the whistleblowers is escalated. Why? Because for the first time, the government will have unfettered access to our communication devices. For example, what they are proposing is to create a monolith institution, which will then in the end be called Potras. The current Potras as it is to become a monster by consolidating it with three major institutions. The first one being Potras itself, then they are going to give it a cyber security center on top of it, a data protection authority on top of it. What they are doing is by convoluting these three institutions, we know very much that cyber security center is a military intelligence type of institution, which the commander-in-chief of the army actually alluded that we are going to utilize that institution to snoop on cyber security and to snoop on usage of social media platforms. What they are simply doing is to say, for the first time, we have unfettered access to private information, which we are going to be using, mainly because Potras, as it is, has access to the back end of all our personal information through the mobile network operators, which they control. So when these things are galvanized together, chances are that the new creature will become classified and moved to the president's office. Hence, it will be difficult to maintain checks and balances on an institution that is snooping, creating a mass surveillance society that compromises heavily on whistleblowing, because you are no longer sure whatever information you are sharing is going to remain confidential. And by so doing, you compromise Section 57 of the Constitution, you compromise at continental level the principles set in the Declaration on Expression, which now recognizes, for example, internet as a right. So we run the risk of missing this golden opportunity to come up, just like, for example, our colleagues in the neighboring countries in South Africa, a fully fledged whistleblowing act, or to come up with a very expansive whistleblowing mechanism in the Cyber Security and Data Protection Act. So that in the end, would have gone through a process that has resulted in furthering and entrenching our right to privacy, which is critical in the enjoyment of our right to access to information. In conclusion, you would also notice that of the close to 16 SADC countries, 15 to 16, depending on the other one is going to move to East Africa or it will remain in Southern Africa, there is only 5 of us with access to information laws. It tells you the state of concerns which the commissioner's mandate is coming when she is assuming office. That beyond promoting the laws, uptake of the laws, there's also need to calibrate practices for those that already adopted the laws. And those that adopted the laws include the most mischievous, such as Zimbabwe, Angola, Mozambique, which are also highly mischievous of violating the very same law which is in existence. So in a nutshell, I want to propose that there's a deliberate move towards calibrating the law and practice, and on the other hand, utilizing the lawmaking process in different spheres of our region to ensure that we consolidate whistleblowing and access to information. Thank you.
Thank you very much, Thabani, for highlighting issues that are happening in Zimbabwe, the challenges, particularly the challenges that are being faced, that whilst Commissioner King has alluded to certain standards that the African Commission has adopted in order to guide state parties in developing, frameworks that are in line with international law and standards, we still face at country level these specific challenges that you are alluding to. And specifically in the Zimbabwean situation, I think it's very important for the civil society to be vibrant in terms of advocating for such standards. And I just want to say, Commissioner King, last year in November, the report on Zimbabwe was considered by the African Commission. The State Party report was considered by the African Commission. And I remember your predecessor, Commissioner Mute, in engaging the delegation of Zimbabwe, made reference to a number of issues around access to information. He identified quite a number of gaps, including the draft information legislation that had been proposed to Parliament. And I think there's still a lot of work to do around that area, and also efforts have to be made around engaging Zimbabwe on the issue of access to information. So I just want to point that out to you, Commissioner King, that these are the situations that arise, you know, when we look at specifically Zimbabwe. And it's not only Zimbabwe, but this is happening in other countries. We have countries such as Botswana, for example, that does not have an access to information legislation up to now, but is pushing towards legislation on cybersecurity, cybercrime, which is very important, but legislation that promotes transparency is not being promoted, and that is work that needs to be done. I will now move over to Dr. Chanel. Dr. Chanel will address us on issues around proactive disclosure, and she will specifically speak to COVID-19 in South Africa. Dr. Chanel, over to you.
Thanks very much, Lingiwe, and thank you very much to the University of Pretoria and partners for hosting this important event today. I'm Chanel van der Berg, and I'm the Deputy Information Officer for the South African Human Rights Commission. I'd also like to thank the other esteemed speakers, Commissioner King, Commissioner Sturm, and the Information Regulator, all protocol observed. Now, currently, the South African Human Rights Commission is responsible for access to information in South Africa. The Human Rights Commission is the constitutional body created in terms of Chapter 9 of the South African Constitution to support constitutional democracy. And indeed, we've heard already today that access to information is central to democracy. Now, the Human Rights Commission is mandated to promote, protect, and monitor and assess all the human rights guaranteed in the South African Bill of Rights. Actually, this includes the right of access to information held by the state and information held by another person that is necessary for the exercise or protection of any right. The South African Constitution is also founded on the values of accountability, responsiveness, and openness. These foundational values that guide our transformative constitution are given expression in this concrete standalone right of access to information. This concrete standalone right of access to information is also given expression to through legislation, the Promotion of Access to Information Act, or PAIA. Now, as we heard from Sheila already, in many countries, the COVID-19 pandemic has meant that countries are declaring states of emergency. It's important to note that in South Africa, a state of emergency has not been declared. This means that none of the rights in the Bill of Rights are suspended, and that includes the right of access to information. Instead, a national state of disaster was declared in mid-March. The government has issued a myriad of regulations and directives in terms of the Disaster Management Act, which is national legislation. Although all these regulations and directions have direct implications on various human rights, like freedom of movement, the right to work, access to health care, access to housing, and access to information, all these limitations must be justifiable in terms of the Constitution. So access to information is more important than ever, as is this concept of universal access to information, which is what we're celebrating today. In times of the pandemic, there is widespread uncertainty and fear amongst the populace. It's therefore imperative for government to ensure that credible information and updated information freely flows to create and foster a relationship of trust between government and its citizens. We therefore are certainly reliant on proactive disclosure. Already before the pandemic hit, the Human Rights Commission, as custodian of the Access to Information Act, has noted various shortcomings with the Access to Information regime in South Africa. But it's not to say that South Africa does not boast a comprehensive constitutional and legislative framework. Indeed, we are one of the few countries who guarantees the right of access to information that is held by both the state and by private actors. Access to information is so important because South Africa, like many other countries in Africa, is slowly moving from a culture of secrecy to a culture of transparency. However, the Promotion of Access to Information Act does not always seem to be fit for purpose in today's information age. There are various shortcomings. One shortcoming is that it's a request-based act. So every time one needs information, you have to fill in a form, send it to the public or private body, and then wait at least 30 days to access those records. It can be over 90 days that you wait if a request is postponed or extended, and third parties have to be notified. And even after those 90 days, your request might be denied based on one of the many grounds for refusal set out in the Act. The Act is also overly restrictive. For example, it does not apply to the records of cabinet or its committees. Now, under the coronavirus pandemic and the national state of disaster in South Africa, it's abundantly clear that decisions taken by cabinet and its committees have very real impact on various human rights and everyday lives of everyone within the South Africa's borders. The Access to Information Act also has shortcomings because of this request-driven procedure and the fact that there is no duty to create records, in that it can be difficult to expose corruption. So as we heard from Sheila, in terms of the UN Convention Against Corruption, there's a lot of steps that need to be taken by governments to create a culture of transparency. So South Africa's Act goes some way towards this, but the fact that there's no proactive disclosure that's mandatory makes it difficult. And unfortunately, we've also come to realize that corruption does not cease during a pandemic. So this free flow of information is necessary to build a relationship of trust, to enable the realization of various human rights that are implicated by the regulations due to the pandemic, and also to expose corruption. The type of information that's especially important is about hospital readiness, COVID-19 cases, and then of course, modeling data. The problem is that this information is fluid, and procurement for example, protective equipment is taking place on an emergency basis. The information is therefore moving quickly, it's moving fast, and it's impossible or impractical to wait 30 to 90 days on a request procedure to access this information. Certain South African political parties have tried to access modeling data for the pandemic and hospital readiness statistics from government, but have been unsuccessful. In any event, if this information is provided on a given day, by the following week, that information would be outdated. This underscores the need for legislative reform to bring South Africa's legislation in line with the African Commission's revised declaration, where there will be a duty to create records, a mandatory duty to proactively disclose certain information, as well as urgent procedures for certain types of information. COVID-19 has also shown us that, yes, we urgently need legislative reform, but we also urgently need to bridge the digital divide that plagues South Africa and the rest of the continent. The digital divide shows that over half the population in South Africa does not have access to the internet. Therefore, their rights to healthcare, education, and information have all been severely prejudiced. There's therefore this urgent need for legislative reform, as well as improved implementation by public bodies. In July of 2021, next year, the South African Human Rights Commission will hand over the dedicated PIA function to the Information Regulator. The Information Regulator will also have enforcement powers to try and implement the legislation more effectively, especially on the part of public bodies. In addition, the Information Regulator will take over from the Human Rights Commission to advocate for legislative reform that will give rights active disclosure and thereby truly support democracy and all the human rights guaranteed in any democracy. So we look forward to moving towards truly universal access to information, where proactive disclosure will be the norm and not the exception. Thank you very much to everyone here today, especially civil society and the media. As we fight for accountability and also corruption during this pandemic, it is clear that a culture of transparency is necessary, but not sufficient. It needs to be combined with an active and independent, strong media, prosecuting authorities and law enforcement, and together both build and work towards proactive disclosure of information and a true culture of transparency where accountability is extracted regularly. Thank you very much.
Thank you very much, Chanel, Dr. Chanel, for your presentation on the South African perspective, and particularly addressing us on one of the cardinal principles when we're looking at an access to information regime, which is that of proactive disclosure. And I think with COVID-19, we have seen how important it is to proactively disclose information. We have seen the weaknesses of the mechanism to request information. Just relying on that, creates a lot of gaps. But if information is proactively disclosed, it goes a long way. And this is with regards to COVID-19, and this is with regards to access to information in general. So when we're looking at the model law on access to information, it's one of those fundamental principles that it emphasizes, and also the adoption of the Declaration of Principles on Freedom of Expression and Access to Information also emphasizes proactive disclosure and also maximum disclosure of information. And it's also very important, Dr. Chanel, that you are talking about reforming the legislative regime in South Africa on access to information. And when you're looking at other countries in the region, we find that most countries, less than half of the continent has access to information laws. And South Africa has led the way on adoption of an access to information law, and now is also leading the way in the realization that in as much as you have an access to information law, it is now lagging behind. It needs to be updated. So in the previous presentations, we had a mention of the right to privacy. Balancing the right to privacy and access to information, both are very important. And in order to look at that balance, or to address those issues of access to information and privacy, and also national security, striking that delicate balance to achieve transparency, I'm going to call upon our representative from Article 19, Eastern Africa, to address us on those issues. And then after Article 19's presentation, we will have a specific country presentation which will look at the situation as it pertains to South Africa, looking at that balance. And I also want to encourage our participants, if you have questions to any of the speakers, to just include them in the chat section, or any comments. Make use of the chat section. We'll have a discussion after all our participants have presented. So please make use of the chat section. I'll now hand over to Sandra Waswa to address us on issues of balancing the right to privacy and access to information. Over to you, Sandra.
Thank you very much, Lengiwe, and thank you to the University of Pretoria for convening this important dialogue for today to commemorate the Universal Day on Access to Information. Thank you also, and it's a privilege to be able to be in this dialogue. As a special rapporteur mentioned that this is her first, and what a timely day to do that. And so also very glad to make her acquaintance and meet her and all other colleagues and participants on this forum. So I have the task of speaking of the right to privacy as it pertains to the right to information. And I think this is actually a very important discussion. It's very current, it's very real. And so, it's very interesting to be able to kind of look at these two rights or concepts together, because I think this is what the world is grappling with right now in terms of the balancing of the right to information, privacy, disclosures, issues of surveillance coming. So it's really something which is at the moment evolving, if I can say that. So I think the first place to start is that to appreciate that both right to information and right to privacy are now regarded as fundamental human rights. And I think that's a very important kind of distinction to, or rather commonality to underline as going forward, is that now they're now in the domain of rights. The right to information, I think, is a bit more kind of nuanced and a bit more explicitly put into legislation and policy as compared to the right to privacy, but they're both now regarded as fundamental human rights. I think that's a good point to make. And actually the conceptualization of this, though, is not recent, and in the Universal Declaration of Human Rights, the appreciation that privacy is a human right was actually already there, in that but it was, an expanded view that nobody shall be subjected to arbitrary interference with their privacy, family, or home. With regard to information, no one shall be subjected to arbitrary interference with their privacy, family, home, or correspondence, and not to attacks upon their honor or reputation. So ideas of reputation were there, and honor and dignity of human life. And that really is what back then looked at the issue of privacy, spoke to those aspects. But now, and there's the appreciation that the right to privacy allows personal autonomy also, while ensuring democratic freedoms of association and expression, such that there should be the appreciation that much as we are talking about rights of privacy, they do not contradict in any way with the rights of freedoms of association and expression, but in fact, serve to enhance them. Because I think when people are secure that their right to privacy, is being fulfilled, they feel freer to associate, freer to, to express themselves. And so there's that, it's more like two sides of one coin. And essentially, the right to privacy gives individuals, groups, and institutions the right to determine for themselves when, how, and to what extent information about them is being communicated to others. And this becomes so important in an information age where, there's so much information and data being collected, amassed, shared, disseminated, whether it's by, for instance, for business purposes, whether it's like, for instance, by the internet service providers, for instance, by big telco. I mean, this becomes a very big issue because people want to feel in control. It's really about controlling what goes out there, when and how often and to what extent, and it becomes a very important consideration to make. And so it has become an element of various legal traditions to restrain governments and private actions that threaten the privacy of an individual. And so far, over 150 national constitutions mention the right to privacy. So the idea is it mentions the right to privacy. But I think one of the things we'll note going forward is that we do not yet have that threshold of protection in terms of legal and policy enhancements to enhance the protection of privacy. And so much as they have a mention in them, they're not yet nuanced. I think this is one area where practice is ahead of policy, in that there are so many evolving things to do with information and data that often the policy or the legislation or the practice lags behind. And that's one of the issues I think we have to appreciate about that. So it's necessary for meaningful democratic participation and to ensure human dignity and autonomy. I think the other thing to note is that therefore, that in terms of the right to privacy, there is no one definition of the right to privacy. And because this is something that still, I think there's a lot of engagement about, and as it's evolving, either people are having wider or narrower interpretations. And that's one of the things that RCI advocates and therefore advocates of right to privacy, we have to consider how we conceptualize the idea of privacy, because it is still at the idea of that conceptualization. But for instance, for us in the Constitution of Kenya, it takes a wider interpretation of the right not to have one's person, home, or property searched, possession arbitrarily seized. With regard to information, it says information relating to the private family or private affairs unnecessarily revealed or private communications exposed. And so how we conceptualize privacy then becomes important for purposes of probably, domesticating or contextualizing it to different countries or to different jurisdictions. But most of the privacy considerations do consider those two things: the right not to have your person, home, or property searched or possession seized, or information relating to your private affairs or your family protected. I think one of the things we have to consider very seriously here as we look at the issue is the extent to which technology has, should I say, infringed or enhanced, depending on how you're looking at it, the issue of the right to privacy. So one thing is that it's agreed that new technology has altered that balance between privacy and disclosure, just by the fact of collection of information being so easier and so much easier, and also dissemination being so much easier. And we have to look at it from two angles, in that on the one hand, technology has enhanced privacy by offering more accessible means to communicate and to access information. So for instance, just on this very call, the truth is that we are able to do this anywhere. More or less, you need internet connectivity. But basic services are also you're also able to access basic services, be it banking services. You're able to do that online now. You don't have to go to a banking hall. To some extent, health services are also accessible. Issues like people don't have to now go, for instance, to post offices. So there's that enhancement of you can do and control where you can access. Technology has enabled us to access, has offered that kind of privacy, if you think of it in that sense. And also the idea of increasing protections online, like the ideas of encryption, have made online transactions and interactions secure. On the other hand, though, technology has also brought in varied threats to privacy, have emerged with the growth of the digital universe, and government surveillance, for instance, is now easier and cheaper. Identity thieves exist. Cyber criminals are there in the cyberspace, and so the intention and the use of computers have forced an expansion in the understanding of privacy. When we think of the right to privacy now, we have to think of it also in the context of those technologies and the new kind of threats that they present. And so also our reaction to that in terms of whether it's legislation, policy, or practice, or putting certain structures in place, have to speak to these new realities, because I don't think we will, we'll go backwards and just keep moving forward. You want to look at it, for instance, if I can give an example of, vulnerability in terms of privacy and the issues of tech. If you think about the issue of children and how their data is used, we've had, I'm sure everybody has seen cases of how children are even groomed, on the internet and then sexually assaulted, or, exposed to such heinous things, and also the use of their data or information, even for instance, for kind of resource mobilization and use of images inappropriately. It gives you an idea that really there's a very pertinent issue here. So a lot of standards with regard to then looking at the issue of privacy with regard to technology. A lot of them are benchmarked from the European context, because as far back as 1971, I think Germany had one of their states legislating around this issue, and then the European Union, the Council of Europe, then came in with with some sort of standards around this, and a lot of data protection policies or guidelines that then came up mimicked that. But it brought us to the advent then of the data protection as an aspect of privacy. And I think that is one area where us as right to information advocates or countries are now looking at that in terms of information or privacy. That is where the legal mechanisms is coming in terms of data protection, which governs the use, collection, and dissemination of personal information, and gives individual privacy as through their information control. So we have to look at the issue. Then it brings us to the aspect of data protection, which is just the practice, in practice means individuals should be able to control who possesses data about them and what decisions are made on the basis of that data. And so the data protection laws essentially seek to protect privacy rights. And so I think that's one of the mechanisms which on a day like this, on a dialogue like this, it becomes important to consider, because we have in the previous discussions considered how RTI laws have been enacted and how are they doing. I think hand in hand with that now goes the issue of data protection. And then so all this information and data has been collected, and how do we look at the protection of that? And so protecting privacy in the digital age becomes essential and good for democratic governance. I think one of the issues with regard to then the data protection issue is that much as information privacy has become very important, there's still a lack of frameworks and processes around this, and even the infrastructure to protect data and privacy rights. So much as there's so much collection by, the big telcos, banks, hospitals, we are not as countries or as a continent reacting fast enough to also look at the frameworks and the processes and the infrastructure to protect data and therefore enhance the privacy rights. And for a lot of states have adopted some form of protection. However, the frameworks are inadequate, so that even where there are some frameworks, they're inadequate because, as I've mentioned, a lot of this is very evolutionary and yes.
Sandra, I would ask you to wrap up your presentation.
Oh, okay. Thank you. Thank you very much. I'm almost actually. Yeah, so states have adopted some form of protection. However, these are inadequate and have not kept up with modern uses and challenges. So there's that idea of are they current, are they effective, and they need updating in order to face the emerging challenges. And so I think the last thing to say probably then in terms of wrap up, because for us on the call here, is then to say that for this being an evolutionary process, is that we need to also consider our engagement with probably as civil society, for those of us of civil society as well as media, in that there's been limited engagement also on our part. Maybe it could be because of the expertise or the capacity, but I think that's to be enhanced in order for us to ensure these processes are participatory, they speak to certain standards, and that they speak to new and emerging challenges regarding data protection. I'm going to stop there. Thank you so much, Lengiwe.
Thank you very much, Sandra, in helping us understand this very delicate balance between access to information and the right to privacy. I'm going to move over to Advocate Strum, representing the information regulator in South Africa. Advocate, please also just before you delve into your presentation, maybe you can make a few remarks about the information regulator. I got a message last week from a friend, and she was asking if Advocate Lakula had stepped down as the information regulator. So I realized that there was lack of understanding on what this information regulator is. So if you can give us paint a picture of what this institution is, and then you can address us on issues on privacy and access to information in South Africa. Thank you.
Thank you very much, Ms. Dube. Advocate Lakula is still the chairperson, she's around. Thank you very much, Ms. Dube, fellow panelists, Commissioner King, and the participants on the webinar. Before I go to the topic that I was tasked to discuss, I'll briefly explain who the information regulator is. The information regulator consists of 5 members, 3 ordinary members and 3 full-time members and 2 part-time members. One of the full-time member is the chairperson, and one member also on the 3 who are full-time is myself. I'm designated and responsible for the promotion of access to information, and it will be Advocate Wipond who is the designated member for the protection of personal information. We took office in December 2016. We are one of the few regulators who have a dual mandate in Africa, meaning the right to protection of personal information and the right to access of information. So we are responsible for 2 pieces of legislation: the Promotion of Access to Information Act, which is the PAIA, and the Protection of Personal Information Act, which is POPIA. Now, as Dr. Chanel van der Berg has said, that as far as our mandate in relation to promotion of access to information, the mandate is still with the South African Human Rights Commission. We'll be taking this mandate over on the 1st of July 2021. Now, I think that's briefly a background in terms of who we are. 3 full-time members, 2 part-time members, co-chair the regulator. We report, we are accountable to National Assembly. We report directly to Parliament. We are appointed by the President on recommendation by the National Assembly. So that's what the regulator is. Today I was tasked to talk about the balance between the right of access to information and the right to privacy in the management of COVID-19. Ordinarily, you'll know that the balancing of rights involves the weighing of 2 competing rights. But in this instance, as far as the right of access to information is concerned and the right to privacy are concerned, these 2 rights are complementing each other in a sense that they seek to hold government accountable to its citizens. Now, as you are aware, in South Africa COVID-19 in South Africa was officially declared a national disaster, and government had to intervene and make regulations to manage and cap the spread of this pandemic. In doing so, I'll start first by privacy issue before I go to the right of access in terms of how we come to the balancing act. Firstly, in relation to privacy, in respect of POPIA provides for the processing of lawful processing of personal information. Now, as you are aware, government has collected a lot of personal information during this pandemic. For an example, the track and tracing, where the regulations were issued in terms of the Disaster Management Act, and they were amended to introduce the process relating to contact tracing, which required the Department of Health to develop and maintain a national database. Now, this national database traces individuals who have or have been suspected to have come in contact with any person who is suspected to have contracted the COVID-19, disease. Now, this database has a lot of personal information in it, including names, ID numbers, addresses. Secondly, our health centers have also collected a lot of personal information, but we are saying in collection of this personal information, ensure that there are adequate security safeguards to ensure that this personal information is protected. POPIA is specifically Section 14 allows for retention of this records of personal information for statistical research or historical purposes. So government can retain this information, but they must ensure that there are adequate safeguards to ensure that this information is being protected. Now, moving over to access to information, we encourage proactive disclosure by government. We're saying the information that government disseminates in relation to COVID-19 must be accurate. And accuracy meaning it will allow citizens to follow the responses to the crisis, such as the restriction rules, regulations of travel, schooling, and virus testing. There should be maximum transparency in terms of when decisions are being made by government and by who, so that people know what is going on. So even the disclosure of these statistics relating to the pandemic is of interest to the citizens. So we are saying proactively, publish health information to ensure the safety of everyone, especially our vulnerable population and people who are living with disability, or for a better word, who are enabled differently. Now, in this instance, communication as far as access to information is concerned is very key. We need to send or disseminate the correct information to all citizens in the language that they understand, because proactive disclosure will, in this instance, discourage the spread of false information about COVID-19. For an example, if you're talking about communicating properly, there has been concept that the quarantine, social distance, self-isolation, self-quarantine. This concept should be properly communicated to ensure that it makes behavior changes to curb and contain this spread of COVID-19. So what I would like to say in the interest of time is that these rights are not competing rights, they are balancing rights, and we need to ensure that we maintain the right to privacy and access to information. But as far as access to information is concerned, proactive disclosure by government is required so that everybody is on the same par as far as this pandemic is concerned, and the message that is being sent across is understood by all the citizens of this country. And by proactively disclosing, citizens will be able to make informed decisions to curb this pandemic. So in my closing, I would like to say, without transparency and open communication, a fair balance between access to information and privacy is impossible. I thank you.
Thank you, Advocate Strum, on those very important remarks. And if we get time, after our two remaining presentations, maybe you can enlighten us on the role that was played by the information regulator during COVID-19, the specific role. So right now we are moving on to a very important aspect of access to information. And I'm going to ask Mr. Alfred Bulakali from Article 19, Western Africa, to give a few remarks and also kind of guide us on what we can do in Africa in terms of strategies to improve access to information regimes in Africa. In some instances, like I've already mentioned, that less than half of the continent have such laws. And if we have such laws, what can we do? And any other strategies that can be helpful if we are looking at, for example, matters of corruption that we have already discussed, or matters of service delivery that we also mentioned. Over to you, Alfred.
Thank you very much, Mrs. Dube, to give me the floor. Commissioner King, Mr. Fran, the director of the center, and dear colleagues and participants, good morning. I'm pleased to talk about this subject. Almost all have been said by my colleague who presented, and I will start it from the call of the special rapporteur inviting the state to take all measures to guarantee, respect, and protect freedom of expression and access to information in Africa. I prepared a small presentation that I'm going to share with you, so as those who can't catch well my English can refer to the document. So please, I hope you see my screen.
Not yet.
I'm trying, and Dube, please give the right to share screen.
Please try again, Alfred.
Yeah, I can. Can you see it now, please?
Yes.
Yeah, thank you very much. As you can see, and as it was said by the special rapporteur, in Africa, we have a good architecture about the freedom expression, and a lot of progress have been made by some states taking access to laws, access to information laws, and implementing them in some areas. But we still have key challenges across the continent, and we could not talk about the strategies without looking at these challenges. One challenge is the different interpretations of freedom of expression and right to information. Another challenge is weak implementation of the standards on the ground, which results in weak enforcement mechanisms, archive system and culture of secrecy, low access to the standards and national laws by CSOs and especially citizens out of big cities, limited capacity and resources for media and activists to conduct investigation where information is not proactively provided by states. We continue to know the absence of access to information laws in many countries, including some that are main like Senegal here, like Democratic Republic of Congo, and others. We can see that in many countries, access to information laws are more thanks to pressure from civil society and maybe national international community peers, rather than the will for accountability in front of the citizens. That results in creation of parallel legislations and repression. How now to address these challenges so as access to information in Africa is improved? I thought it in 6 points. Distinguish right to information from other rights associated with freedom of expression. Policies on access to information, and we need a real political commitment for transparency and accountability. And finally, we need citizen demand and engagement, and somehow to rethink the model of Africa for human rights, access to information, and public accountability. Why not? As I said, we can't dissociate access to information and other freedom of expression rights. So as access to information to be effective, in our countries, we need to protect and respect right to protest. Independence of media, other digital rights like Sandra was explaining, and protection of those in charge of ensuring access to information is effective, such as journalists, human rights defenders, whistleblowers, and other activists. Of course, we need strong laws and policies in each country with empowered institutions to enforce them. That's to be there, we need remaining countries to adopt these laws on access to information and making sure that those laws are compliant to international and African standards. Where we have those laws, we need to make effective the law enforcement mechanisms. Because one issue is that we have laws that institutions to make them in application are not created, or are not, or if they are created, they don't have enough resources and capacities. To repeal or revise any existing parallel laws or anti-access to information legal provisions. As I said in the challenges, some countries have access to information law, but at the same time, they have adopted or keep legal provisions that are opposite to the essence of access to information itself. We need to build capacities of law enforcement officers and actors. In many countries, we have this access to information laws, but the public administration itself, they don't know what is it about, or the African standard, what they are about. Countries need to invest in building capacities of their institutions and access to information application. And of course, if we have all this and capacity built, we need people in charge to. If we have all these people by institution and people violating access to information laws, should they count for it? That will be the foundation of realizing the right to seek, receive, and impart information. Having law should not be seen as an end by itself.
Sorry,
can you catch
Alfred,
me, please?
Rounding up by now.
Sorry?
You should be rounding up your presentation.
Yes, I'm almost done.
Yes.
So second, we need an active and empowered civil society and media so as to enforce the public action control, to pursue advocacy, to monitor progress and report on. Transparency and accountability of public actors is necessary, and they should be only guided by that to realize the enjoyment of access to information that is finally a sustainable development for their citizens. Without demand and engagement of citizens, we can't have the action of civil society legitimated. So we need more engaged citizens that demand for access to information, because simply it's their right, because that enables them to control the action of their states, and because that will enable them to enjoy their different rights and protect them. Finally, we need to question the model of AU. And here I don't have a specific strategy. I only left questions for us, and some of them will need enters in the discussions that are ongoing about the AU global reform, aiming to know, are the AU itself transparent enough? Are they trusted by the people in Africa? What are the sanctions against states that do not comply with access to information? And what powers are given to special rapporteur and political independence so as they can hold government accountable? So those are the key points in which I thought we can have the access to information in Africa strengthened for now and Thank you very much for your attention. Shukran.
Thank you very much, Alfred, for taking us through some of the strategies that can be used in improving access to information in Africa. And as we wrap up, I just want to also call upon William Bird to kind of reflect on what's happening in South Africa with regards to the law that is currently in place, which is the Promotion of Access to Information Act. And going forward, what are we saying about this law? What should be done? What is the civil society saying about this? This speaks to law reforms. And in Commissioner King's keynote address, she mentioned aspects around adoption of appropriate legal frameworks in order to support and access to information regime. So we want to hear what the civil society in South Africa has to say about the situation in South Africa going forward. William.
Good afternoon, and thank you so much for giving us this opportunity to speak. It's fantastic to be on Commissioner King's first public outing. I'm also patently aware that I'm what's stopping you before lunch. Normally you're in a room and everyone's itching to run out and go there, but now I guess in our own Zoom offices, if we're lucky, we can just step out and grab something, but I will be quick. But I'm hoping that what we have to say is really important and will leave us on a very positive light at the end of this particular fascinating webinar. I've really enjoyed what the speakers have had to say. So really, we've heard so much about the importance of the right to access to information. We know how it gives meaning to our constitutional values of accountability. I'm so delighted to hear the emphasis on the importance of people getting access to credible information. And I realized that actually I neglected to introduce myself. I run Media Monitoring Africa, which is a non-profit organization. We do a lot of human rights-based work around policy, around strategic litigation. We've been doing a lot around disinformation recently. And so those calls around the importance of journalism and their ability to do their job properly is really critical. So this, what I'm presenting today and what I'm going to speak to today is really on behalf of the organization I run, Media Monitoring Africa, as well as the South African National Editors Forum. And it's drawn together by a group of expert access to information lawyers. So we've heard about this right. We've also heard from Chanel and other speakers. Sorry, Dr. van den Berg, forgive my informality there, about how our existing law in South Africa, our Promotion of Access to Information Act, when it came into being in 2000 was really an incredibly progressive piece of legislation, but it's now 20 years later and in urgent need of reform. And Dr. van den Berg talked to a few of those elements. So what we've been doing over the last few months is Media Monitoring Africa and SANEF and other like-minded organizations supported by information activists and legal experts. We've embarked on a process to draft proposed amendments to PIA in an effort to ensure that it realizes the right to information in a timely and effective manner. So in looking at this, we've looked at some of the amendments drawn on by the work of the South African Human Rights Commission, some of the issues coming from our courts, as well as civil society actors, journalists, in identifying some of the critical shortcomings and pitfalls that currently exist. So what we're doing is also trying to make sure that our PIA exists within our regional framework. So we've drawn extensively on, and these are really magnificent documents, particularly the African Commission on Human People's Rights, through the Declaration on Principles on Freedom of Expression and Access to Information. That should be on everyone's bedside table as reading when you want to feel inspired and alive every day, as well as the guidelines on access to information in elections in Africa, those equally exciting and lovely, as well as the modern law on access to information. So we've looked at those, and in the digital era, it's important that access to information is fostered online and offline, and some of the other speakers have touched on that in a lot more detail. So we know that a lot of disclosures that are made through different platforms render information accessible to the public, and it's really important that we talk to some of these principles. So to give you a taste of what they look like, we can tell you that the principles that our amendments have been based on the following 5 key principles. Firstly, primacy. One of the key challenges we've had is that people say, oh, well, PIA doesn't take precedence over another piece of legislation. And in fact, what we're arguing is that primacy, access to information as a constitutional imperative, should be treated with appropriate primacy over other laws. And so we looked at using that as a key hurdle, key principle. The next one is maximum disclosure. And this is the right of access to information should be guided by the principle of maximum disclosure, with the right only being limited by narrowly defined exemptions that meet the test for reasonable and justifiable limitation. And again, this is from daily experience with journalists, where they might get access to some things, but then they don't get access to all that they actually need. And the principle should be maximum disclosure. Linked to that is the one that's already been touched on today, and that's proactive disclosure. Information in the public interest must be proactively disclosed, even in the absence of a specific request. So rather than have to wait for public bodies, especially to reveal and release information, they should just be actively going out and putting it out there. It's the most effective way of helping people get access to information. Fourthly, international commitments. We must be able to abide by international commitments on access to information, including in respect of critical open government and open data standards that are driven to a large degree through our partnership of the Open Government Partnership. And these commitments to help us move towards openness on a proactive basis that are deserving of being effectively filled. The fifth principle is online protections. So in the current digital era, the exercise of the right of access to information must be respected, protected, and promoted both on and offline. And this places a particular duty on public and private sector actors to ensure that in fulfilling their obligation, due regard is had to the medium format in which information is made available. Of course, we use this opportunity to highlight again, and a point that was made by other speakers, the importance of everyone on our continent having access to cheap, fast broadband, reliable. So underlying these principles that I've just gone through is a core concern about the efficacy of PIA. So one of the things is, it was a great piece of legislation when it first came up, but it wasn't as easy to use. And so over the years, we've seen a number of issues have come to the fore, which is that bodies sometimes delay, they stifle, or they give you little bits and pieces of information. And really the amendments must look to address those shortcomings. Now, it's well accepted that access to information plays a particularly important role in democratic processes and empowering the electorate to make informed choices. So this includes in respect of electing office bearers, participation in decision-making, lawmaking processes, holding private and public sector actors accountable for their acts or omissions and execution of their duties. And moreover, the right of access to information fosters a vibrant media culture that plays a central role in receiving and imparting information. And this is more important than ever in our new digital age. So as we look to the future of access to information, we continue to strive for a society underpinned by our constitutional values and democratic governance. So while PIA is one of the instruments through which this can be done, there's a lot to do before the right of access can be meaningfully realized in South Africa. Now, this public announcement today that we've been working on a draft on our efforts to reform and improve PIA follows on months of work by a team of lawyers to incorporate the principles that we referred to above and address the problems encountered by members of the Access to Information Network, journalists, as well as others in their efforts to use PIA. The next step is we're going to be approaching a group of PIA users and experts to make sure that their concerns are captured in the draft amendments. And the final step will be to hand us over to the South African Human Rights Commission and the Information Regulator, as well as the Department of Justice, for consideration and processing by the Executive and Parliament. So if you would like to learn more or get involved in the drafting of the amendments or add your views to it, we would that'd really be welcome. And please just reach out to me just after this. But thank you so much, and I hope you all have a fantastic International Day of Universal Access to Information.
Right on time. Thank you very much, William. So you have given us highlights on what is being done with regards to amendment of PAIA, and in acknowledgement that it's high time PAIA catches up with standards that are defined in the model law and also in the declaration. So this is how we have structured the webinar. The special rapporteur set tone for us, and then we had presentations that touched on country-specific context, what is happening in Kenya, what is happening in South Africa, what is happening in Zimbabwe, and also even in other countries as well. And then we had an acknowledgement again of the balance between the rights to privacy and also access to information, and we had Article 19 and also the information regulator in South Africa, and also an emphasis on proactive disclosure is the cardinal principle of access to information. And then now we then moved over to going forward, what can be done, what are the strategies, and then giving a specific example of what exactly is happening in the context of South Africa. So that is the picture of access to information in Africa that we wanted to paint using this webinar, and in commemorating this very important day. So just 2 minutes to say a few words in light of what has already been said.
Thank you very much, Lingiwe, and thank you very much to all the speakers for such wonderful presentations, particularly highlighting that yes, a lot has been done, but there's still a lot more needs to be done. And I'm particularly interested in the emerging issue of the right to privacy. As you know, the Commission has done a lot of work around access to information and expression issues, but we have not actually pronounced ourselves on the right to privacy, and it's important that we follow on the discussions and the dialogue around this issue. I want to thank all of you for sharing and for making this day very meaningful in terms of our commitment and re-energizing ourselves to continue the work on access to information and all of the issues that are involved, and making sure that within our national jurisdictions that we have effective, not only laws, but effective laws and laws that are implemented and monitored so that our citizens and individuals living in our various countries can actually enjoy the realization of access to information. Thank you.
Thank you very much, Commissioner King, for those concluding remarks. I am sure from the presentation, it's very clear to the African Commission that indeed there is still a lot of work to be done around the area of access to information. And now with the digital age upon us, we are speaking of embracing the fourth industrial revolution. What does it mean for access to information, and what does it mean for other rights? What does it mean for such important aspects such as access to internet and other supporting infrastructure that we need on the continent? And it's also the digital age is coming with issues that need the attention of the government, such as protecting national security in the digital age, combating cybercrime, strengthening cybersecurity. So all those are new issues. So now we leave it up to the African Commission to also provide the necessary guidance to states on how to embark on journeys of law reform, policy reform. And it's a good thing that, at least for now, the African Commission has adopted the standard setting documents. that you presented on, Commissioner, the model law. It's available on the Commission's website, and organizations that are working towards, on access to information can actually use those instruments, such as the model law, such as the guidelines, such as the declaration on advocating for these rights, from an informed perspective, or from the perspective of the African Commission, or from the perspective of international human rights law, because that is where these instruments draw from. And also, as the Center for Human Rights, we are thankful, we are grateful to everyone for participating in this webinar, for time to commemorate with us this important day, on freedom of expression and access to information. Thank you very much, Article 19, Western Africa. Thank you very much, Article 19, Eastern Africa. We appreciate you, Transparency International Kenya, Media Monitoring Africa, and other civil society organizations in South Africa that put together the example of what is happening in South Africa. To extend our thanks to the information regulator in South Africa for also highlighting issues of access to information and the right to privacy. And I think, and MISA Zimbabwe has been playing a very important role in highlighting issues on media freedom, issues on access to information, issues of whistleblower protection, and has been playing a very important role in working on the law reform exercise, specifically the freedom of information law, and also the data protection and cybercrime law in Zimbabwe. So we thank you very much for the partnerships that are being developed and continue to be developed, and also the continued support of the mandate of the information regulator. As you can see, that there's a lot of work that needs to be done, and the African Commission needs our support. So thank you very much for your time. Have a lovely day. Bye.
Yes.